Good morning, everyone. I will just start with our karakia. Whakataka te hau ki te uru, whakataka te hau ki te taonga, kia makinakina ki uta, kia matarata ki tai, kia hiaki ana te atakura, ki tio, ki hoka, ki hauhu, ti hei, mauri ora.
Okay, tēnā koutou katoa, nā mai haere mai ki tēnei hui, ko Robert Scott, tapu ingo. Hello and good morning, everyone. Welcome to hearing 15A, which concerns all things related to zoning requests for the Carrington Estate Special Zone, Kauri Cliffs Special Zone and the Open Space Zone, all related to the proposed Far North District Plan. My name is Robert Scott, I'm the chairperson for these hearings, and with me is Councillor Felicity Foy and Commissioner Siani Walker. Formal stuff that I say at every hearing. This is a hearing under the Resource Management Act. What did that say? Hearing about to start. This is under the Resource Management Act to consider submissions and further submissions on the proposed Far North District Plan. We've been appointed by Far North District Council and to make recommendations to the Council on any changes to District Plan as it was notified. We're not intending to issue interim recommendations at this stage, and we'll be hearing all of the submissions before issuing a complete set of recommendation reports. That said, we will hold interim deliberations at the conclusion of each hearing topic. Until our final recommendation reports are released in late March in 2026, any of those deliberations will remain confidential. My background is in planning, and I've been a planner since last century, 1992, and an independent commissioner since 2014. I mainly practice in Auckland and the North Island and in Queenstown, but I'm also a commissioner for a number of local authorities around the North Island. I'll just get the other panel members to introduce themselves to you, starting.
Ati Mārie, ko Siani Walker tōku ingoa, ko te ati haunua paparangi o ku iwi, ko tupoho, rawa ko Ngāti Rangi, ko rawa ko Ngāti Tamakōpiri o ku iwi, ko Siani Walker tēnei. So I'm a planner by profession, at a consultancy, Bentley & Co, and been a commissioner since 2019, and in particular my area of expertise is around te tiriti, integration of Māori values, cultural heritage. Kia ora.
Kia ora, Felicity Foy Ho. I am an elected official, but my background is also town planning. I'm a full member of the New Zealand Planning Institute, and I live here in the beautiful Muri Whenua, and you might have seen a few of my signs out. I'm also in my role as an elected member here on the panel.
Great, thank you. Just before, and finally, I just need to check with our commissioners as to whether you have any conflicts of interest. No, that's good. So I don't think we have any procedural matters to deal with today. Does anybody wish to raise any of those? No? Okay, well then what we normally do with each hearing topic is we allow the council 10 to 15 minutes to introduce the various chapters that they have been reporting on. That's usually done on a PowerPoint presentation, so I'll throw it over to them and then we'll get on to our hearing our submissions. So, Mr. Willem.
Thank you, Mr. Chair. Mr. Kaitāia will be opening up today.
Good morning. So as mentioned, today's hearing is based on rezoning general, Kauri Cliffs and Carrington Estate. Oh, go back on slide. Each topic will talk about the overview of submissions, key matters for consideration, and the key recommendations. In terms of the general rezoning requests, there were 5 original submitters and 11 further submitters. The submissions came from mainly government organisations, key interest groups and individuals. The key matters raised were rezoning land to natural open space, concerns around zoning misalignments, identification of mapping and rezoning errors, and support for amendments in Plan Variation 1. The key recommendations were rezoning land to natural open space, removal of rural production zoning in Opua, and rezoning land above mean high water springs to mixed use, and retaining Plan Variation natural open space zone related amendments. There was no evidence submitted for this topic. And I think
Morena, Chair, Commissioners, Submitters. My name is Jerome Wyatt. I'm the Reporting Officer for the Kauri Special Purpose Zone and the Carrington State Special Purpose Zone. I'm just going to provide an overview of submissions and some of the key recommendations of my weekly report and some outstanding issues in rebuttal evidence. So in terms of the Kauri Special Purpose Zone, generally a limited number of submissions on this Special Purpose Zone, 24 original submissions and 32 further submissions. And they were primarily from Wildlife Farm, who you have here today, but also some submissions from general organisations like Fire and Emergency New Zealand and Transpower. And there's also a range of further submissions from Moana Kip, who was generally in opposition to Wildlife Farms Limited's original submissions. And also just to note that Wildlife Farms chose to opt into the rezoning process for rezoning submissions outlined in minute 14, so that allowed for a lot of evidence exchange between technical experts and some refinement of provisions. Just in terms of some of the key issues and recommendations, one of the most substantive requests from Wildlife Farms Limited was around the reconfiguration of the three subzones that sit within the special purpose zone. And the key sort of change here is the relocation of the golf living zone to the north, and that's kind of a key change because that allows for up to 60 lots of residential subdivision. I'm recommending that is amended as requested by Wildlife Farms, and that's for a range of reasons. It's generally supported by the technical experts. And the key point to note is that further development of that golf living area will be subject to a more detailed consenting processes in the future where effects can be assessed in more detail. A range of amendments have been sought to the provisions themselves from Wildlife Farms Limited, primarily to improve workability and clarify the intended outcomes within each subzone. And just to note that the evidence from Mr. Tuck in terms of what he was requesting is much more refined than what was in the original submitter, so that made things a lot easier in terms of refining the provisions. So I'm recommending a number of amendments. Most of these are mainly sort of workability kind of issues. For example, amendments to policy 5 and 6 to clarify the activities anticipated in each zone. Some amendments to the standards around the GFA thresholds for buildings and height limits, and replacing uncertain terms with more precise terms that are used in the PDP and national planning standards, such as visitor accommodation and residential activity. Wildlife Farms was requesting amendments to subdivision rule 3, and as it relates to the golf living subzone. I'm recommending that the minimum lot sizes are reduced to 500 metres squares as requested by Wildlife Farms, and the idea being here that really provides an opportunity to cluster development and reduce the overall visual impact across the site. And there's also a number of additional conditions and matters of discretion to make sure that landscape effects and other relevant matters can be properly assessed. I'm not recommending any submissions in response to the general submissions. That's a relief sought. It's not appropriate for the special purpose zone in my view. In terms of the outstanding issues, so Wildlife Farms has lodged rebuttal evidence, but at a broad level, I think there's general agreement between myself and Mr. Tuck. And with the outstanding matters, largely matters of detail and refinement. And then includes correcting some minor drafting issues and provisions. There's some further requested amendments to matters of control and discretion, which have been informed by the landscape advice from Mr. Goodwin, and also just to note that Malene, our landscape expert, just came back in from overseas on Friday, so she hasn't had full opportunity to consider those amendments, but we will in due course. Further refinements to subdivision rule 3 in terms of the conditions and matters of discretion. Also clarifying some of the issues that were raised in the technical reviews of the evidence in terms of ecology and geotechnical issues. For example, the map shown there, which sort of highlights the intersection of indicative sort of development next to ecologically sensitive areas. And we've also received rebuttal evidence from Ngāti Kura on behalf of Moana Kif, who's raised a number of outstanding issues with development in this area. That's Carrington, so I'm happy to take questions now or just move on to Carrington Estate.
Do you want to make some comment about the evidence received regarding Carrington? Do you want to make a comment now, or would you like to do that at the end of the proceedings?
Of the rebuttal evidence, or just
in
general?
Yeah, in general, yeah.
In general, it's been high quality in my opinion, and it's been quite a collaborative sort of exercise, I think, between myself and Mr. Tuck in terms of refining the provisions, and it's generally been a good process. And they chose to opt into the Minute 14 process, and that, as I said, that it really allowed for collaboration, refinement of provisions, and it's made the outstanding issues much more refined, in my opinion.
Any comment about the Ngāti Kura evidence? It seems to be fairly refined in terms of the issue that it's raised.
Yeah, no, I would actually like to hear from the wildlife farms themselves in terms of responding to some of the evidence in their relationship. I know it's
no, that's fine. I'm happy for that to be the order of proceedings.
Yeah.
You don't have questions?
Save it.
No, I'm happy to.
Okay, no, thank you.
So Carrington Estate, somewhat similar, but also quite different in terms of the issues. Again, relatively limited number of submissions, and they were primarily from Carrington Estate as the owner of the site, and also from Kaitāia Marangi Malai Kaitāia Trust. I knew I was going to get that wrong, so I may refer to them as AQMKT. But I think we all know who we're talking about. No? Kaitāia Trust. So in terms of the issues and recommendations in relation to Kauri's Estate Special Purpose Zone, a number of requests to remove the references to the Carrington Estate Development Plan and schedule and provisions. In my Section 42A report, I recommended that be retained. We've subsequently got planning evidence that's raised additional issues about that, which I think we'll consider in due course. A number of amendments to certain provisions to better protect cultural values and not from environmental values. And rather than sort of amend provisions per se, I'm just providing a clearer link to those chapters that deal with those values specifically and provide that really strong direction to protect those values. So that includes amendments to the overview section and Advice Note 1 to provide a clear signpost to district-wide factors, including natural features of landscape and coastal environment, etc. And a minor amendment to Policy 5 to refer to areas and sites of significance to Māori, just to better align with other terminology in the PDP. Carrington Estate has requested that some of the operative district plan rules relating to traffic, earthworks and vegetation clearance are reinstated in the PDP, and also to make primary production permitted activity. I'm actually recommending the car parking requirements are deleted from the schedule, because that relates to the MPSUD requirements to remove minimum car parking requirements, which applies across the district, not just to Kirikiri and Waipapa as a tier 1 environment. Recommending retaining the district-wide earthworks and vegetation clearance rules and a new permitted activity rule for farming, which is required in the PDP rather than primary production more generally. The request to extend the coastal environment overlay to cover the full special purpose zone in addition to general submissions on the zone. I'm not recommending any changes to the extent of the coastal environment overlay. I think it needs more detailed assessment to support any recommended changes to the overlay, as the mapping is based on the RPS maps. And also some requests from Carrington Estate to rezone some of the areas of land to general residential and light industrial zone. And I'm not recommending any changes if there was insufficient information to support those requests. So there's In terms of the outstanding issues, we've generally got quite divergent views between Carrington Estate. The planning evidence from Carrington Estate is generally supportive of most of the Section 42A recommendations, but reiterates their request to reintroduce some of those ODP provisions relating to transport, earthworks and vegetation clearance, and just generally requesting that these activities be permitted in accordance with the development land plan. We've also received cultural planning evidence, receiving significant concerns about the development that has been undertaken in Carrington Estate to date, and ongoing concerns about the incorporation of the existing consents being incorporated into the ODP and now into the PDP. And the key concern there is it's this regulatory overlap between the consents and provisions that refer to the development plan and schedule. There's also a more broader concern about the need for the special plan altogether and whether it meets the criteria and the national planning standards around the special purpose zone, and also the geographic extent there, which you can see on the map there, which is from Mr. Percy's evidence, where he's suggesting the zone should be refined much more down to the actual development area, not the wider zone where primary production activities have been undertaken. The general concern around the lack of clarity and certainty in the provisions. And also just to note that legal submissions were received on Friday. I haven't had an opportunity to view those in detail. I think that's my presentation.
Any questions? Presentation. Great. No, thank you very much to both reporting planners. Right, so I think we'll move on now to our first submitter, which is the Waiawa Bay Farm Limited, otherwise known as Kauri Cliffs. Ms. Bugsida, you're going to lead the charge. Now, you've got your legal submissions with you.
I do, and I have to confess by start by confessing that my heart desires me to stand up, but I feel like this is very slightly disrespectful.
Well,
just
no,
you sitting.
you take it from our look. Well, I'm short enough as it is. So now, please be said. Look, if you feel more comfortable standing, then feel free to stand. But we're trying to run these hearings reasonably informally, so feel free to sit.
Thank you very much. I do have 5 copies of these. Thank you very much for permitting me to not present these. I very much appreciate the opportunity to talk you through them. They're very brief.
That's right. No, we've got plenty. We actually got a reasonable amount of time today, so don't feel like you're pressured to race through your submissions or your summaries of evidence and your Thank you, Tom.
So my name is Nicole Bugsida. I'm legal counsel for Waiawa Bay Farm Limited. I'm joined here by Ms. Tapper, who has provided evidence, and she's here and able to speak to the panel. Also have Mr. Goodwin, landscape.
Morning.
I have Mr. Tuck. We're joined by Mr. Robertson, who's travelled over here, who feels this proceeding is very important, and he is here. Located at 139 Tiffany Tablelands Road in Matauri Bay, Kauri Cliffs is a world-class facility that has been a significant contributor to the local and regional economy since 2001. Kauri Cliffs is home to a luxury lodge, a top 10 ranked David Harding designed Pass Institute golf course and a working farm. Kauri Cliffs is owned by Waiawa Bay Farm Limited, which has landowner interests throughout the North and South Islands of New Zealand, and a long history and connection with the place that we live. From 2023, Rosewood Hotel Group were appointed to manage the lodge. However, the golf course, farming and forestry operations continue to be owner-operated by the Robertson family. Waiawa Bay Farm has invested and continues to invest significant time, effort and expense in developing Kauri Cliffs to the high-quality world-class feature it is today, and that is the reason that we're here, is continuing investment and stepping into the future. The notified version of the proposed Far North District Plan provided for development in the Kauri Cliffs area. The nature of the changes sought by Waiawa Bay Farm Limited is that of a reconfiguration of the existing subzones within the Kauri Cliffs zone and a clarification of the notified plan provisions. And I think the Section 42A report also used that clarification word as well. That's why we're here. Now, I have provided 83 copies of the zoning and the proposed reconfiguration, if that would be helpful.
Yes, thanks. Otherwise, I've just got it on my small screen, so that's really helpful.
Got
Thank
a
you.
big copy, isn't it, for everyone here?
Okay.
Because I think because we are looking to sort of reshuffle this, I find this really helpful in terms of my head around it, and I have to admit it won't necessarily be me talking you through the reshuffle. It will be Mr. Tuck who's done the significant planning legwork, and I appreciate I have 3 candidates on the panel in front of me, so I suspect that.
So we're all going to be confused, right?
It's just that front one got a cover page and the rest don't. Is that right?
Yeah.
Yeah, we can share it. We can share it and you can
Okay.
put a copy of
There
it.
should be 10 copies of the table.
Yeah, we have
But
it.
you've actually got
I think you might have
the
something.
master
Oh,
plan.
you got the master, oh,
Yeah.
my apologies, 1 copy of the master plan.
Yeah.
And then
we've got
it's-
drawings.
We'll just share up the
Share it and
Okay.
district plan.
yeah, that's I have those notes.
Yeah.
Actually,
Side by side.
yeah, makes it much easier if we.
We're just going to interfere with the stapling and put them side by side.
The descriptions down the bottom should be in appendix, and we can, Mr. Tuck can put them.
Yeah. So
The
Mr.
royal
Tuck,
we.
we're reasonably good at playing spot the difference, but if Mr. Tuck could just sort of take us through those things with.
We're very happy to explain sort of where we're going, where we came from, where we're sort of planning for that kind of and visually it's really important to see it. As mentioned by the council planner, the changes sought by Waiawe Farm Limited are generally supported by the Section 42 report author and the supporting reports to that. Where clarifications were sought, Waiawe Farm Limited provided additional information and answers in reply to it. And Mr. Goodwin and Mr. Tucker here to answer or talk to that. But I would like to say Waiawe Farm Limited has appreciated the council's involvement and constructive approach throughout this. It's been very positive and we appreciate the work, the responsiveness that's gone on. There's been this robust process. A version of the Kauri Cliffs zone and relevant subdivision provisions incorporating the provisions recommended by the Section 42A report author and the replies in response to the Section 42A is included in the reply of Stephen Tuck. Now, my intention for this was so that the commissioners had one set of plans, or one set of provisions, which tracks changes on top of the Section 42A. So I'm hoping that that will show you any outstanding clarifications or issues there, so it can hopefully be a building block to see exactly where we're hoping to go. A summary of the changes sought in the current position. Waiawe Farm Limited seeks reconfiguration of the Kauri Cliff zone and the rural production zone in order to apply the golf living subzone to more appropriate areas and to extend the lodge subzone to cover an existing subdivision and enable future development complementary to the existing lodge. Evidence clearly supports that the zone reconfiguration is likely to produce improved environmental, amenity and commercial outcomes. And I'd just like to take this time to note that all experts agree that the proposed reconfiguration is appropriate and that further detailed assessment will be prepared at the resource consenting stage. Paragraph 9, I take you through the evidence provided by Waiawe Farm Limited. And I thank the Section 42A report author for the indication of the high quality nature of that evidence. Ms. Tapper is here today. She will be available to answer questions. She confirms the Robertson family's commitment to the property and the many actions taken to preserve and protect the area. Ms. Tapper also sets out the rationale and need for a reconfiguration from a hosting perspective. Now, I note the Commissioner's comments and the Section 42A report author's comments in reply to the submission. I am planning to say a few comments, but I suspect that the person best placed to talk about the relationship with local iwi is Ms. Tapper. And we've discussed this, she's happy to answer questions on this, but she's on the ground, she's got a working relationship. And the consultation that's been undertaken to date has been set out in the evidence of Steve Tuck, but I think that that fails to paint the full picture. Ms. Tapper and the relevant iwi representatives are very happy to pick up the phone and talk to each other, and this happens on a frequent basis. There is a preemptive discussion. My understanding is that this happened over the weekend. There was a text exchange. There is an open line of communication that has been developed through intentional efforts. There's been a lot of work put into this. And I think that the table of meetings might not quite paint the depth of that ongoing relationship. We have evidence from Mr. Bramley, who deals with ecology, He opines that the area proposed for reconfiguration as the Gulf Living subzone avoids high-value ecological areas, and that any potential effects arising from future subdivision and residential development can be adequately managed through plan provisions, a detailed ecological assessment and resource consent conditions, again at the resource consenting stage. Mr Goodwin, who's here today, deals with landscape. He considers that with the proposed control measures and requirements at the resource consenting stage, including preparation of a detailed landscape effects assessment, the proposed zone reconfiguration and future subdivision and development will result in no more than minor adverse landscape and visual amenity effects. He considers the proposed amendments are appropriate. We have Mr Child dealing with geotechnical, and he considers that the reconfigured Gulf Living subzone is generally feasible for development subject to suitable detailed geotechnical investigations and design undertaken to support resource consent applications for future subdivision and development. And again, we come back to the future detailed designs at the resource consent stage. We have Mr Papesh, who considers that the potential effects of future subdivision and development will be addressed at the resource consent stage by preparation of a detailed civil engineering assessment and implementing appropriate design solutions. And he considers that the practical servicing requirements, including water and access, can be provided. On the page, I summarise the evidence of Ms Tatton, who deals with archaeology, and she states that there are no direct archaeological or other historic heritage effects resulting from the reconfiguration proposal. She considers that future resource consent processes will be appropriate to identify and manage any potential effects. And I note that these experts are not here, however, they've all set aside their morning and are available in Teams should the commissioners have any questions arising. Last up, we have Mr Tuck, with planning. Mr Tuck considers that appropriate consideration of the environmental effects of future activities in the reconfigured zone, including if matters significant to iwi, will be addressed at the resource consent stage and regulated by the preparation of detailed assessments to inform subdivision and development design and resource consent requirements. Mr Tuck notes that his recommended amendments to the provisions are no more permissive than the notified plan, and that some recommended amendments are in fact more restrictive. Mr Tuck considers that the proposed reconfiguration is suitable and appropriate, satisfies section 75(3) of the Resource Management Act, and is an improvement on the notified zoning such that it is a more efficient and effective way to achieve the objectives of the proposed plan in terms of section 32AA of the Resource Management Act. I touched on engagement with iwi and I've had a few comments about this, but I note that Waiawa Bay Farm Limited consulted with representatives of Te Raunaga o Whangaroa, Ngāti Kura Hapu, Te Raunaga o Ngāti Rehia and Matori X Incorporation, who identified key considerations which would need to be considered prior to resource consent applications being lodged, including preparation of a cultural impact assessment at that stage. And as Waiawa Bay Farm Limited said to the EU at that time, Waiawa Bay Farm Limited will ensure a cultural impact assessment is prepared at the resource consent stage. None of the iwi who chose to engage with Waiawa Bay Farm Limited raised any concerns about the overall feasibility of development proposed in the master plan, and indeed support was expressed. And as I've said previously, Mr Tuckfield sets out those consultation steps, but again, I think Ms Tamper is probably best placed to answer questions about that relationship. I turn to the Section 42A report. There are no major areas of disagreement between Waiawa Bay Farm Limited's experts and council experts. Where council's experts have requested greater clarification or suggested changes, these have been provided in Mr Tuck's reply and supported by Mr Bramley, Mr Goodwin and Mr Child. Over the page, I deal with evidence from Te Whānau Nui o Waiawa o Ngāti Kura. Waiawa Bay Farm Limited agrees that a cultural impact assessment will be required. However, it considers that this and other detailed assessments are most appropriately completed at the resource consent stage for the following reasons. Firstly, the purpose of a cultural impact assessment is to manage effects, and the evidence shows there are no effects arising from the reconfiguration of an existing zone. The potential for effects arises for assessment most appropriately in the resource consenting stage. Secondly, other iwi parties are comfortable with a cultural impact assessment being prepared when subdivision and development design is more advanced and the cultural impact assessment can be more appropriately focused. And thirdly, resource consents will be required to authorise subdivision and development. These consents will require a cultural impact assessment. Waiawa Bay Farm Limited thanks the submitter for the indication that 6 months will be properly required for the preparation of the cultural impact assessment, and intends to ensure that this time is provided for production of a cultural impact assessment by the relevant iwi prior to lodging resource consent applications for residential subdivision in the Gulf Living subzone. Commissioners, in summary, Kauri Cliffs is a world-class facility which has helped promote New Zealand, and more particularly Northland, as a premier international tourist destination. It has been and remains an important contributor to the local and regional economies. Further development planned for the site will expand that contribution. The changes recommended by the Section 42A report author, and those consequently sought by Waiawa Farm Limited, are minor refinements supported by comprehensive expert evidence. The recommended provisions provide a future development path for Waiawa Farm Limited, which will ensure responsible environmental protection and enhancement alongside proposed development. A cultural impact assessment and other detailed technical assessments will be most appropriately prepared at the resource consent stage. Thank you very much.
Right, thank you very much. So I take it from these legal submissions, there's no substantive legal issues for us to address?
No.
Okay. I have just one question, and I'm happy for you to provide an answer now or get a number of witnesses to address it. It's about the cultural impact assessment. That is, so is your client satisfied that a CIA is not needed to support the zoning requests, and that it's more appropriately, and that's where I want to explore, because I think the evidence we received is that you need a CIA to support the zoning, not necessarily the development. So if you could just comment on that, that'd be helpful.
Our approach here has been that a cultural impact assessment is more appropriate at the resource consent stage, because there will be more detailed design, there will be more understanding of exactly what is proposed, exactly where it's going to go, how it will work. And from a initial perspective, no, but there was preemptive consultation, there was preemptive discussions with iwi. No issues were raised at that stage. Nobody was uncomfortable with the fact that a cultural impact assessment would be required at the resource consent stage, and so my client proceeded with that. The archaeology evidence indicates that there's nothing arising out of this rezoning step that causes any indications of concern. There is absolutely no intention to avoid in any way the preparation of a cultural impact assessment. The consideration is that it's more appropriate and more orthodox to have that at the resource consenting stage rather than at the rezoning stage.
Okay, and so in that sense, it's your client's view that the cultural matters that have been raised have no material effect on the zoning request, that it's only at the development stages. Is that sort of like a clunky summary of where your position is?
And I wonder if I take this a little bit further, and I think this is more an exploration on my part. My reading of the evidence and the reply evidence by the submitter is that there may be breaches arising, but the evidence and the further evidence doesn't specify what those might be. And we're here in a process, there's been notification, there's been consultation, we're here talking through the proposal. It's difficult for us to see what the breaches could be. We have not tried to identify those. That's not our place. And I think that might be where the commissioners are a little uncomfortable, where I haven't directly replied to this. I don't feel that's appropriate. But I have turned my mind to this quite a bit. I can't identify a situation which a breach would arise, given that we're here in the process. But that's why we're here, so I'm sure we'll hear from the submitter. Okay,
no, thank you for that. I'll see if the other commissioners have any questions for me.
Just one. Under your evidence 14B, it states other iwi parties are comfortable, and it wasn't outlined who the other iwi parties are.
Sorry, that was maybe a summary on my part. The other iwi parties are outlined in the evidence of Mrs. Tote.
Yeah.
And I know that Ms. Tapper has discussed this. That's where they confirmed to her that they were comfortable with the production of a cultural impact assessment at a later stage. My understanding is that no concern has been raised at any point throughout this, where Waiawa Farm Limited has had meetings, has had consultations, has had site visits with the iwi. No issue has been raised about the lack of preparation of a cultural impact assessment. The first notification of this was for us when we received the submitted evidence.
So when you say iwi, in 10 it says the runanga, so at a iwi level, but then also notes, and also Ngāti Rehia, it also notes at the hapu level there, so the site visits were with hapu or with the runanga or iwi representatives.
Yeah, so when we talk about the site visit, we're talking possibly about the one that, a few months back now. We did have at that, it was Johnny Strongman, who is a member of Te Whānau Nui o Waiawa, and his son also joined us that day, and we had Aljon, sorry. Yeah, so that was on the site visit. And there has been consultation prior as well. So that sort of started back in 2022, would that be right? When you first, I think Arnold Kira was consulted at that time as well. And so I've been sharing information quite widely as we've gone as well. So, as much as I can. But that's the consultation that I think you're referring to, as well as with Ngāti Rehia as well on our Sunbelt border.
It's been good.
Thank you. A couple of questions. Has there ever been a CIA done for the Waiawa Bay in its historical development? Not to my knowledge.
There have been archaeological investigations. A section of the site was volunteered for protection under Taonga. Burial caves were set aside, specifically volunteered by the owner and protected in during owner forwards. That was done in consultation with iwi, and my understanding is that has been a very special process for all parties involved. And that continues. That's something that Waiawa Foundation is very proud of. So there have been very responsive reactions to sacred sites on the property.
I saw the mention. Okay, thank you. Thank you for that response. The question that I sort of wanted to ask, so in the master planning process, can I sort of ask what was the input that those iwi parties that participated, what was their input in regards to your master planning? What did they sort of suggest, ecology, water quality? I don't know, I'm just asking. What was their input as part of the process?
Certainly in terms of once the draft master plan had been prepared and shared, feedback, there has been feedback around, particularly around concerns around water treatment, and water is actually one of the main, was one of the main concerns expressed, and that was Geraldine Baker, particularly from Makoti X, and also Aljon through the Runanga. As far as that was in response to the draft master plan, just to be fair. So that was, shared first and then, feedback invited. Has it been responded to? I think most of the steps that the rezoning submission had was addressing some of those concerns, particularly around where moving living areas away from the waterways. And then early on, before the master plan was even started, this was before I held the role that I hold now. I believe that it was consultation with both Ngāti Rehia, Aruru for Ngāti Kura, and the Runanga. I'm looking for confirmation because Steve was there and I wasn't. And I believe that was before the master plan started being drawn and put together. But it wasn't, it was at the draft stage that was provided and feedback invited at that point. And from that, we had meetings that, we had an online Zoom, invite everyone to attend with our experts so that any of those concerns could be raised. I believe there were modifications taken on, including, it was at that point actually the CIA was first raised, and we confirmed that would be something, in fact it was in advance of that, that we would definitely be doing. And so, so that's how we're sort of going.
just on that, no, that's really helpful. And I hesitate to answer because I wasn't as I said, Ms. Tamper has been running this sort of relationship. But in terms of consultation, it hasn't been a fait accompli where the master plan has been presented and there's been no chance for input. There's been, it's been a back and forwards process. And we have experiences on the property where, especially talking to Anu, who has said this is inappropriate, that has been observed by they've changed the plans in response to that feedback. So it has been consultation, it hasn't just been a here we go.
So there's quite a bit of reliance on a CIA is appropriately done at the resource consent stage. What I want to ask is a couple of questions actually. Who has the relationship with the iwi? Is it the owners? Is it the operations? Is it Miss Amy? And a resource consent process is transactional. Hey, we're doing this, we want to do that. Whereas a relationship is different. It is that I could call up and say X, Y, Z. So I suppose my first question is the relation? What is the relationship? Relational, transactional. Especially the resource consent process will be pretty much transactional. And who has got that relationship? If Miss Amy was to be run over, who would hold the relationship from there?
Can I?
Yes.
So probably primary as the person on the ground. That relationship is with myself, and it's something that I've been working on building and developing over the past few years. But very much alongside Jay Robertson, who is one of the owners. Alongside me as much as his availability allows, but I think most people would have his email address as well. So if I got hit by the bus, I'm hoping that he would step in, someone would pick up that relationship. I think where it gets more complex is that we do have a business and management company running our operation, the hotel operation, and they also have a key relationship on the ground as well. But I would say that's developing as well. But the primary relationship with our neighbours is something that is with me. The, access way to the, various areas on the property. For both, we have Ngāti Reo here who use our roads as well as we have the whānau down at Waiwa Bay. That's through me as the first port of call ultimately. And then, so those relationships are happening. I think we're building, and I think Jay put it best, it's a series of steps, and we're working on that, and I hope, that we're heading in the right direction.
So just to jump in there, put it in a structural sense, the day-to-day relationship is with your role, so the bus analogy, not sure there's public transport up there, but if you were to not be in that role, it would be the successor to your role that would have that relationship. So
I think so.
You're the manager of the.
My role's owner's representative. So I work for. So I've had a long history working. I've worked for 20 some years for the family, and primarily a lot of that has been with the lodge. In the last 2 to 3 years, I have transitioned out of that lodge operational role, and now I'm supporting the whānau or the family here as their representative on the ground. They are, they do live offshore, and it's important, I think, for the family to have someone representing their relationships here.
So structurally, it's the family's representative, that's you, and then there's an actual ongoing relationship with the family themselves.
The family, right. That's right, yeah.
I just wanted to put that in a structural sense as opposed to people.
We're a small team, so there's not layers, but I think Jay will step in if I get hit by the bus.
So your official term is representative of the Robertson family?
Owner's representative.
Owner's representative.
Correct.
Something to refer to it as we owner's representative. Okay. Okay. Sorry to jump in.
I understand that.
I know, and half the time I'll say me and ours and we, like I own the properties, which I don't. But 20 years in, I'm waiting for the shares.
Well, it's that sense of ownership of the relationship that doing. So,
And if I could make a comment here, the relationship that I've seen as legal advisor is multifaceted. You know, there's not communication on one topic. There's calls to Amy about access. There's calls to Amy about, you know, these plans or these questions. There's all sorts of things. It's not just a one-way road. It's a multiple strands.
Yeah. Okay.
that's enough from me.
Good, thank you.
Thank you.
Anything around?
Not at this stage.
Okay, that's all of our questions.
Thank you. Well, I was going to say, I know it must happen.
Yeah.
She has a summary of evidence.
I've said half of what I was going to say, so.
To read if that's all right. So my experts produced summaries that it's okay for the commissioners if they read those out.
Yes, we have read all the evidence, but we're happy to be reminded of what the main things are.
Yes, all very brief.
And anything new that may have arisen. So yeah, so you can, if you've written a summary, feel free to read it, or just take us through it. We're sort of in your hands, and as I said before, we've got plenty of time. So.
Yeah. Well, I mean, ultimately, we've covered off you've covered off the history of the property and Kauri Cliffs and how it's developed where it is. You know, I think it's only benefited our region. You know, so it's provided great employment and career opportunities for Northlanders, local suppliers. Our economies have benefited from that business, and the capital spent to date, but also where we're heading and the hope. You know, that part of why we're here. You know, the business has strong relationships locally, and I think that's both for the hospitality operation, but also for the golf and the farm operations. I think importantly is just that for the Robertson family, that this is an enduring commitment to Kauri Cliffs. So, you know, this is a forever, and a lot of this planning is part of how do we continue to develop from here, and make this the greater premier visitor destination. The family, in my time of working with them, and it's been quite long now, you know, they're incredibly proud of the commitment of their connections to New Zealand. They want to be great neighbours and they want to do the right thing. And, you know, part of that even is my role being here available to be part of that sort of, you know, that contact for our neighbours as well. Environmental stewardship is sort of key. You know, I think Kauri Cliffs has benefited from a huge amount of investment, continues to, with planting, you know, native planting, restoring habitat, retiring pasture, all of those great things. But you can, you know, even looking around the property just yesterday, you can just see it, and I think it's continuing. You know, we touched on that we strive to be good neighbours. We, for our future, you know, we'd like to develop additional visitor amenity, continue to grow that business and the reputation that we have for excellence, responding to what our clientele from the lodge perspective and the golf perspective are looking for. And part of that challenge that we've faced is that the lodge zone area, now I get the terms wrong, but the lodge subzone, the lodge subzone is compressed. And part of the submission that we've made is to increase that space, to incorporate the area that has existing subdivision in it, and which will allow future growth. And that's, you know, staff car parking, all of the things, gymnasium with it, and the clubhouse, different things and facilities. And those facilities are also important to a future residential community. So it's sort of twofold on that front. The other piece was for this future residential community, the current zoning is compressed between that lodge operation, the farm operations, probably less impactful, but also the golf maintenance facilities. A lot of that area is entirely surrounded by the business operation. And I think the premium lifestyle that we're proposing to our future residents, that's not appropriate or not the best outcome for them. You know, privacy and serenity is probably the most important. So that the forestry and the golf maintenance operations aren't ideal. So that's one of the key things that we're looking to move with this submission. And then I think there were you had questions around the EV relationship. I don't know if you had more questions from where we've got to at all that I can share in terms of the process of how we've got to where we are.
One question I had, sorry, if you're the chair, one question I had was Moana Kif and the whānau. Yep.
Wow.
Do you know what that relationship is or isn't, or how it's
got to
the
where we are?
dynamics of it, I suppose?
Yeah. Good one. I mean, it's a relationship that's developed. It's, on a personal level, obviously, it's warm. Moana is able, you mentioned text messaging, Moana texts me on the weekend for access to get down to Waiwa Bay. And I'm able to facilitate those requests. There's a history to how we've got to where we are, I think, and, Moana will have her own, feedback on that. A lot of it, or from what my take on it has been, historically the relationship between the Robertson family has been, and as it pertains to Ngāti Kura, has been with Anaru Kira. And he's been a great supporter, but also advisor to the family, Robertson family, over the years as it comes to the developments at Kauri Cliffs. And as I mentioned, in 2022, Anaru was shared with Anaru this initial planning submission that was going in. There was a resource consent and building consent for a pavilion, or batch facility down at Waiwa Bay, which was consented 2 years ago. 2 years ago, and we recited that building, in response to Anaru's feedback. In reading Moana's submission, I think Anaru's submission for Y375 was noted, and it talks about in his youth, where there was a burial site, that he had been moved before our time. But it's that he asked us to move the building for that we were proposing, which we did, right? And so there's that. And so the history has been, and I think at the time that Moana found out about it, it was not communicated. We didn't know. We didn't know. And once we found out, this is where the relationship with the Waiwa whānau has, we've got a lot of, tried really hard, and we are trying really hard, and we continue to strengthen that, because it wasn't there before, and I think it's there now, and I think it can continue, which can only get better. But that's the history, I think, of how we've got to this point, perhaps. I'm sure there's greater concerns, so I've simplified it a little bit, but yeah.
Okay, thank you. But at least we've got the awareness that there is some form of connections and engagement.
Yeah, definitely there is a relation. Yes, definitely, and absolutely with a number of who we've spent time together.
Thank you.
Kia ora. Point 9, just clarification around the word ideally suited, or the term ideally suited. So just some more context around that, please, because it talks about farming, agricultural maintenance and forestry activity, with the ambition to essentially change that so that it overlaps with business and operation.
So that's about where, and I might not have worded it correctly. So where the proposed, where the current zoning is, it's compressed between areas of the property where those operations are happening. So there's golf maintenance on one side, there's a forestry as well, and then there's the golf course and lodge. And so it's hard to do. I think you're coming tomorrow, so I might be able to show you. So there's a large part of it is through, Steve, you might need to help me here. You're just showing it, the green? No, yeah.
So that's the area that is because it's increased, as you say. So just refers to.
So if you look at figure 1.
It's team effort, yeah.
So I'm trying to, so this so the front page, this green area here is being removed from, that's the piece that's being moved. And so the reason being, this is the golf course and lodge operations. Along this side is golf maintenance, there's forestry, and so it's sort of compressed between, there's also a waterway at the bottom of it. So not ideal for premium living, you know, home with all of that business operation happening around you. There's a lot of vehicle movement, lawnmowers. So, yeah, we're targeting a premium, you know, residential development where I think privacy is a key part of that amenity and you know, people are coming for the quiet. So the business around them won't work so well.
So you're wanting to move it from a busy place, potential of reverse sensitivity issues for residents. So, because when you say forestry activity, it's not like people cutting down forest, is it? It's just...
Well, we harvest. We will be harvesting.
So there's harvesting actively.
Yeah, in fact, it's a commercial forestry.
Okay. Good context, thank you.
Nothing further from me. My other commissioners asked some very good questions, so I have nothing to add. So thank you very much. I think I might as well let everybody know we are going to be going out to visit the property tomorrow. Ms. Tapper has kindly offered to escort us around property so that we can see all the things that we need to see. And you understand that we're not going to be receiving evidence from you. We're not going to be doing a deal. And she'll basically just be pointing at matters of fact to help our understanding. So thank you very much for your evidence and the answers to our questions. You may have some further input yet. We'll see how we go. I think we all need to sort of start doing musical chairs, I'm afraid. Mr. Goodwin is up. Good morning, Mr. Goodwin. How are you?
Hello, now
Morning, Commissioners.
Summary.
You've got a summary statement as well?
I have.
Yes,
I have.
great, thank you.
Thank you. Summaries.
I will email Carrington Commissioner Penny copies of all these documents.
Yeah, and also see those.
Take over later.
Has everyone got a copy statement? Great. We're in your hands, Mr. Goodwin.
Well, just by way of introduction, my name's John Goodwin. I'm a landscape architect with Bottom School. I've been practicing for well over 40 years now. So yes, getting along in the tooth. And I've been working for Waiawa Bay Farms at Kauri Cliffs since 2021. So have been very involved in the reconfiguration in particular of the zoning and the preliminary master plan. And I guess it's important to emphasise that it is a preliminary master plan, but there was a lot of work that went into that, which also helped to shape the reconfigured zoning. And Ms. Tapper obviously discussed a number of those things around conflicts that are happening within the site. But also from my perspective, it's about really consolidating development in an area, particularly in the Gulf Living Zone, whereas previously it was potentially much more, could have been much more sporadically laid out across a vast area of the site. And I guess as a landscape architect, when I look at a property like this, I look at it as in a kind of land use management sense as well as a visual sense. And I think there are some key areas of the site. Clearly, there's the lodge hub, as I call it, which the Waiawa Bay Farms are looking to have some increased density there, incorporating the existing subdivision, which to me makes complete sense. There's the golf course, which is really in an area of much broader open space, but framed by farming. And if I can just show you, we can refer to the third map you've got there. Sorry, I'm diverting from my my statement, but I think it's helpful background to.
We're in your hands, Mr. Bullitt.
Introduce.
If you'd like to guide us through your remarks, we're happy.
Okay, so it's also called Figure 1, but it's the third sheet of those, and you'll see that the purple area with the crosshatch is the area of golf living zone that's now been deleted. And I guess by way of my reference of looking to consolidate now the golf living zone, it's consolidated into the green areas, whereas previously it was spread out much further to the south, but also to the north. There's still some areas to the north which are not shown. And when I really looked at the overall, how the 60 lots, which were already part of the original zoning, could be configured on the site, I felt that could be detrimental to the golf playing area. And whereas at the moment, that area where you play the golf, it's in such a beautiful environment, and to have houses kind of aligned within that visual catchment, in my view, it was better to consolidate them into a much smaller area. And so that's why previously we had over 280 hectares in the golf living zone. We're now down to 122. So it is a consolidation, and you have to look at that carefully because you can have houses more closely together. But I think clustering development in a landscape like this is preferable than spreading it out over a much longer area of the coastline. So that's a kind of philosophical, I guess, approach to how and it wasn't just me, there are obviously the geotechnical engineer and the archaeologists and a lot of work with the planners. But as a philosophy, I think that and from a landscape output, I think that's a better outcome, and so that's really focusing on that configuration.
If I can just jump in with a question. So is it in that philosophy, is that the amenity values that you get from playing golf at Kauri clubs is about not seeing dwellings?
Well, that's my view, and I believe the owners have kind of bought into that. Yes. You don't have it now. Certainly you see the lodge, but that is the lodge and the golf approach, that's part of that. And I think to intensify that and have a lot more open space around that is a good outcome. I mean, clearly there are golf courses that have houses lined along the fairways, but this is not one of those. So, yeah.
Okay, no, thank you.
So sorry, that was a divergence from what I intended to do, but I thought it might be useful. So just going back to my summary, paragraph 1 just outlines that I submitted landscape evidence in May 2025, which supported the zoning amendments, not just the reconfiguration, but the others, which I'll touch on as well. And then following reviewing Ms. Absalom's her review of my evidence and the 42A report, I've submitted rebuttal evidence. Paragraph 2, my evidence in chief concluded that the proposed zone reconfiguration, which I've just really highlighted, and the provisions, and in particular the building height footprint restrictions, the colour design controls, building platform requirements and mitigation measures would enable future subdivision and development at Kauri Cliffs that will result in no more than minor adverse landscape and visual amenity effects. So that was my summary from my evidence in chief. And I guess the key things in relation to that is that there will be a maximum permitted height within the golf living zone of 5 metres within the coastal environment, which is consistent with the coastal chapter, which I also presented evidence at, and 7.5 metres beyond this. And 7.5 metres is actually less than what's permitted in the rural zone, which I understand is 9 metres. but we were happy to do that, given the relationship to the Gulf Living Zone having some coastal environment area and some adjacent rural area, and felt that the relationship there would be better configured with a permitted 7.5 metre height limit.
That would still enable a two-storey dwelling?
Correct. Yes. Yeah, and we felt that was appropriate just to allow, a more extensive view if you're outside that coastal environment. So,
would it mean you would be locked into a certain type of roof design, or does it? Could you do a gable roof as well?
You could do a gable roof, yes. Yeah. Whereas the 9 metre, and we debated the 9 metres potentially would allow you to get 2-storey and a basement, which is a different kind of configuration again. Now that's fine in a much more inland rural environment, but the Gulf Living Zone now is, even if it's not in the coastal environment, it's still proximate to that area. The second point is, and this is consistent with the coastal chapter, is the use of natural building materials and particularly recessive colours. And I think that's sort of accepted pretty much across the board now. And the maximum building footprint of 300 square metres throughout the Gulf Living Zone. And then we've brought in to play the 5 metre permitted height limit with for the extension of the Gulf Living Zone over the consented subdivision located to the north, and then use the 9 metre permitted height limit for extensions to the south and west of the lodge. And the reason for that is that that residential area to the north is away from the main lodge building, whereas the 9 metres around the existing lodge, which is quite a, is a building of some scale, will then be consistent with that and allow you to consolidate the existing lodge building. And then, of course, in paragraph 4, if for any reason those requirements are wanted to be exceeded, it becomes a restricted discretionary activity. And from my perspective, there are landscape matters that need to be addressed there and carefully considered. And those amended and those zone provisions are outlined in Mr. Tuck's evidence, and I've had input into that as well. Importantly, paragraph 5, as part of any subdivision and development within the Gulf Living Zone, a landscape assessment will have to be done as part of the resource consent. And I think that's an important thing. That'll have to be done by a professional landscape architect. And so even if it's not me, which I've had an involvement in with this and the master planning, someone else will have to go through a similar process and identify suitable building platforms, areas of sensitivity and mitigation and kind of land use proposals. And that also includes the preparation of a landscape planting and management plan. And I see that as a document which would guide particularly planting, but also ongoing management of the farm and the areas around any buildings in terms of how those buildings would then be integrated with the land use, but also the coastal environment in particular. And that's really with the overall objective of integrating any development into the surrounding property, but also the broader landscape context, and particularly the coastal context. So paragraph 6 is the key things that I addressed in my rebuttal evidence. And I guess they're kind of minor in one sense, but I think they're also, words become important when a plan gets put into place. So And I've been drawing on the Section 42A report of Mr. White, and I think that by and large we're certainly in agreement, and he's been dealing with Mr. Tuck obviously, and there's a lot of agreement around what these provisions are intending to do. But I'll just quickly run through a few of them, and if you would like me to expand on any of them, I can go back to my rebuttal evidence and go into them in more detail. But the first one is in relation to an additional matter of discretion, and that's in paragraph 7 in my rebuttal evidence. So you may want to just have that sitting beside you as well, because that refers to the actual provision. And I guess the two changes I'm suggesting there, or the main two changes, is, well, there's three actually. Perhaps if I deal with the deletion there, which is to delete the words including by clustering development being set back from high points and major ridge lines. Now, while I don't disagree with that in principle, there are a lot of other things I think that may be important when looking at development and subdivision within the Gulf Living Zone. And so rather than single those out, because sometimes it is actually better to build on top of something rather than on the side. So if we're on a very steep slope sometimes, particularly if it's facing towards the coast and you do a lot of earthworks, it can be a worse outcome for a building or a structure than if you build on top of a plateau. And a lot of the new Gulf living area is on relatively flat, on what I would call a broad ridge. And if you then start to say, well, we shouldn't be building on ridges, when is it a ridge and when is it not a ridge? And there are no identified ridge lines. There's no outstanding landscapes for a start on this property, which I think is an important point. And there's no identified important ridge lines in the proposed plan. I think, we're not dealing with things that have been identified as being particularly sensitive on the site. So rather than have something that directs that very literally, my preference is to delete that, but to also add the words that we should be minimising adverse landscape and visual effects. And I think the word landscape there is important. It's not just about the visual, it's about the landscape, and that includes the landform and vegetation as well. So those are the changes that I've suggested, and Mr. Tuck's picked up on those as well. So that was that particular rule. The next bullet point relates to paragraphs 11 and 12 and 15 in my rebuttal evidence. And this is in relation to the landscape planting and management plan. And it seems a minor thing again, but my suggestion is that to emphasise that the main purpose of the landscape planting and management plan is to integrate development into the landscape, rather than just that it is the purpose, because I think there are a number of other kind of sub-objectives or sub-goals in association with that plan. And I've gone into a little bit of detail here, but in my main evidence, it certainly outlines what those things are. So it's through planting, it's through minimising earthworks, all those sorts of things. So I think that's a useful addition to that provision. And then the third bullet point, once again, it's the introduction of the word landscape in there rather than, I think the previous, if I just go to paragraph 16, I'll just refresh my memory. Yes. Yes, it's the landscape within the special purpose zone. Manage potential adverse effects on the characteristics, qualities and values of the landscape of the special purpose zone. So just emphasising that we're dealing with the landscape again. And then the final bullet point deals with paragraph 2021 in my rebuttal evidence. And that's a deletion in relation to, this is in relation to the lodge subzone, replacing a paragraph, deleting and replacing some words there, which really focus on any adverse visual effects and the extent to which mitigation measures ensure that such no more than minor. And Mr. Tuck can talk to that in more detail in terms, or all of those actually, in terms of how they have been incorporated into his recommended changes to the provisions. Me not being a planner, I know the reasons for doing these things, but it's the word, but I'm happy to leave to the planners.
Yeah, that's right. And so we need to go to Mr. Tuck's rebuttal evidence to see how that word landscape is actually weaved into those provisions.
Yes.
Perhaps I'll telegraph this to Mr. Tuck. If you could help us understand where Mr. Goodwin's further changes have been iterated into the provisions. That's part of your summary. That would be.
I know he's prepared for that.
Yeah. Yeah.
No, thank you.
So just for clarity, you've talked about the rationale of 300 square metre maximum building footprint, and you've talked about in terms of placement of buildings, there's no actual specified building envelopes.
No, that would come through with the when you do the subdivision and the development plan for the resource consents. Yeah.
Yes, but also further to that, the actual the area that previously was in the Gulf Living subzone has been significantly reduced.
Yes.
But also, I can see with the green, the actual shape factor is a lot narrower and gives more clarity about where those sites can go. I hope this is here later in these.
Master plan?
Yes.
The preliminary master plan? Yep.
Yes. For example, on page.
The next page, isn't it? Map
yes.
1?
It gives indicative clusters.
Yes.
So although there's not specified building envelopes, you've done that in clusters. Can you speak more about that in that context?
Sure.
I think these diagrams are helpful.
Yep, sure. Yep. So go back to it might be the previous map, the one that's map 1 it's called. I'll just by way of introduction, if that's all right, I'll explain the overall concept.
Mm-hmm.
So in looking at the site together and all the consultants work together on a day where we we walked this whole area and also Pip Cheshire from Cheshire Architects was there as well. He did have quite a lot of input into this as well, and we worked very closely together and felt that there's an opportunity for two sorts of housing developments. There's the clusters which you talk about, and I'm happy to talk about them in a bit more detail, but also the purple dot squares, for example, are more what you might call single, more like family homes. They're more homes rather than smaller units that are clustered together. And those different typologies of buildings and living environments were determined by the landform and the landscape. And so all of those larger, slightly larger squares are all along what I call that broad ridge. So they're all there's room to kind of space them out and have more open space around them. Whereas the other smaller clusters of development are all more within a kind of a basin environment. And you'll see this tomorrow when you go there, actually, it'll become much more apparent. It's hard, it's always hard looking at a plan, but when you're on the site, you'll see, hopefully you'll say, that's what he means. Because you'll see that there's almost an amphitheatre, and there's some kind of logic in clustering buildings within that, or within in the southern area around it, some existing trees, for example, which provide a strong vegetated context for those buildings. So that was the rationale there. So if we go to the page that you referred to, which was it the next one? No, it was the one after, must have been. Was it 15 you're looking at, or 6?
Yes, so just some of the visual examples of, it's called it a cluster.
Yep. So, well, it's figure 15 and 16 I can refer to either one, but so that is in a more confined area. It's lower down off the more plateau land, and there is we agreed that there was good opportunity to cluster buildings together within that environment. They're kind of more contained by landform and vegetation, and so they wouldn't be so prominent within the broader landscape visually. That was the kind of the master plan. But acknowledging that this is still preliminary and there's a lot more work to do, and that there may be a different sort of outcome with further work that's done on the site. So I guess just in conclusion, paragraph 7 that I refer to Mr. Tuck, and we've talked about that he will take you through those in more detail. But given those comments of mine, I do support the amended provisions to the Kauri Cliff Special Zone. I consider they will provide a robust set of controls to ensure that future development or subdivision and development will result in an appropriate landscape and amenity outcome. So,
thank you.
Yeah, I'm happy to answer any questions.
Yes, I've got five questions and possibly some supplementaries. I'm really interested in this relationship between the master plan and the provisions. So that's sort of the context of a number of these questions. And I'm just thinking, what the master plan is as a document. It would be fair to say it's sort of like the touchstone, it's the foundation-based document that the zoning related special purpose zone provisions are based on?
Yes, yeah, it's a guide. It's a guiding document.
Yeah, I think it's more than guiding though. I think it's it's like a baseline touchstone, fundamental document.
Yeah.
It's the basic analysis.
Yes.
And the assumptions that result from that analysis that lead to certain planning provisions and approaches and related.
Yeah, no, that's fair.
So in that sense, and I'm happy if you don't think this is within your area of expertise, but you sort of meander into planning a little bit. So I'll ask it. Do you see the master plan as like a fundamental Section 32 document and the analysis behind that?
Whether it's Section 32 or not, you'd probably better to ask Mr. Tuck, but as an analysis behind the future development of Kauri Cliffs, I certainly agree with that.
Sure. And my next question then is the master plan expected to be a living document in the sense that it's not frozen in time? This is not frozen in time? Is it meant to be frozen, or is it meant to be a living document that gets
that will evolve?
Yep,
no, definitely. And sorry, just building on that, I mean, Kauri Cliffs, irrespective of the master plan, are doing through their own initiatives, and this has been mentioned earlier about doing a lot of revegetation, taking out wetlands and gullies from grazing and fencing them and replanting them. And so I think all of those things need to be identified, mapped and documented, and they all build the picture of what Waiawa Bay Farms will eventually become.
Yeah. So, given its importance to the provisions, but also acknowledging that that you want it to be a living document, what do you understand as the process by which that would be updated and changed?
Well, yes, taking the Gulf living zone as a piece of that. I mean, the reason that I've recommended that there is this landscape and its planting and management, but the management part in particular is a key, you know, and I know Waiawa Bay Farms, you know, it's obvious that they have to manage the property, and they do manage it. They manage it very well, and they manage it for the right sort of uses. This area is good for farming. This is being retired. This is golf, blah, blah, blah. So I think to me, a similar sort of overarching document across the whole farm, and it probably doesn't need to be as detailed as around, you know, a development area necessarily, where you've got people living and you've got buildings, but over the whole property. And I think my understanding is that the farming operation is and Mustafa can probably answer this better than I can, but my understanding is that there is a lot of documentation about the farming that goes on. Now, whether that should be or needs to be drawn into an overall document, I don't know, but I think management is something that's ongoing there anyway.
Yeah. One would think that the principles behind the master plan would remain.
Yes.
And that they wouldn't change, or that would require another process, or a more in-depth process, if we were to change those basic principles. Would that be a fair assumption?
Yeah, I guess yeah. I mean, things can change over time, but I think the fundamental essence of the place is something that needs to be reflected. Yeah. Yeah. Okay. The values. Thank you very much. That was the word.
Yeah, I'd say principle, but I think values. Values may be a better way of putting it. Thank you.
Yeah.
Okay. Thank you. And you helpfully just referred to the LMPP, which the Landscape Management Planting Plan.
Yeah.
And I was going to go there next. So, is that to be a living document, or is that actually a plan that remains reasonably fixed?
Well, I think within that, some of the things that would likely come out of that would be the management part of it would be identifying areas, particularly of vegetation, that would need to be managed over time, you know, and that would include things like pest and predator control, for example, which is already going on within the property. So it's those sorts of things that would be ongoing, and I think associated with that, there's typically would be monitoring as well. So how are we doing with that, and how we're therefore improving the biodiversity of the place.
And have you built into that management plan process any consultation that would arise if you were to update and amend it?
Well, I think
particularly with key stakeholders that we know of.
Yeah, I think typically that in these sorts of places, I think that is an important consideration.
Yeah. Do you think it needs to be recognised in the wording of that that consultation and engagement with key stakeholders would be a part of any updating of it?
Yeah, certainly for some of those details around plant material, for example.
And it might be some quite mundane things, but it might be really important things, right?
I don't think they're mundane. I think they are important. But, I think the more day-to-day, because there's a lot of knowledge around plant species and appropriateness and relationships and flora and fauna as well. So, there's a lot to learn there.
And finally, my last question, and it goes back to these clusters again. Obviously, you put quite a bit of work into thinking at a high level, where would you want clustering to occur? And I think you've gone about a sort of like a basic layout of how it could be iterated. And I'm just wondering, how would this work? Obviously, there is some rigor behind the identification of these clusters, the number of them in each one and where they're located. There's obviously been quite a bit of rigor to that. And I'm wondering how that indicative clustering would inform a resource consent appraisal down the line. Now, the master plan isn't referred to in the planning provision. Mr. Tuck's come up with a planning opinion about that. It's telegraphing that to you, Mr. Tuck. But forget about it being referred to in the provisions. What I'd understand is from your landscape perspective, would you expect the rigor that you've already done for clustering to inform a resource consent process down the line?
I think the rigor, but I think the outcome could be different.
Yes. Yeah,
and you know, whilst the owners are aware of what we've done here, I don't, you know, I don't know. I haven't personally had any, you know, close briefing in terms of, well, this is the kind of outcome that we'd like. So I think, you know, I wouldn't like to see this become a blueprint or anything like that, but I think...
You don't want to ignore it either.
Beg your pardon?
You don't want it to ignore it either.
Well, I don't want the... well, that's where I think the provisions that we've got, that there will be a landscape assessment done, and as part, you know, with a team of people, and obviously there are others involved in that, and as part of that process, the same sorts of analysis would occur. And I guess I'm very conscious of time as well, and this may happen quite quickly. It might happen in a longer period of time, and it's quite likely to happen in stages. And so I think, you know, the land use and landscape, there can be some changes through that time. So I'm very conscious that I'm not wanting to freeze this.
Yes.
As a blueprint.
Yes, I get that.
I'm nervous about that, you know, and because you say there's quite a lot of rigor, but it's only to one level. It's at a very conceptual level, and then it needs to go to a much more developed design level. There's a lot more information that needs to be drawn on in order to, you know, give some real shape to these clusters, for example, like access and levels and all those sorts of things.
Yeah, that's right. So what you're saying is, this cluster makes sense at a high level.
Correct.
But once you get there, you go, oh, how am I going to get a road there?
Yes.
And look at the retaining that needs to be done to put it there and that sort of thing. But and obviously this is a common tension with sort of master planning instruments, is that to what extent do they end up becoming default rules? And I understand you don't want that to happen, and that's not what I'm suggesting. What I'm saying is that there is some level of analysis, but quite a good level of analysis in there, and that potentially would help inform future decisions. You wouldn't say it's a rule, but you go, well, based on that analysis, putting it over there makes sense too. What do you think? So that's one of the things I want to explore, is how you have regard to all that work and how it becomes relevant to down the road when there's a consent process.
Yeah, no, so I mean, your earlier term about it being a bit of a touchstone, I think, you know, is a fair comment, and I guess it would be silly to tear this up and throw it out the window.
Yes.
Because someone's going to have to start again.
Well, you could imagine a scenario down the line, you know, where you say, the planner says, well, hang on, it's got to go there. And then, you know, a planner, you know, and or a lawyer would say, well, hang on, this document isn't in the zone at all. And I think the answer is somewhere in the middle.
Yeah.
Okay, thanks. That's my questions. Some questions, Sarah?
Yes, thank you, Mr. Goodwin, for that presentation and the reference to the mapping as well.
Okay.
So just one question that I have. with the master plan not being set in concrete, you know, its values are there, be them conservation, be them environmental. A question I have is, do you think there's an opportunity for a CIA to be done for the site to inform the evolving master plan, with that master plan, you know, building cultural values in the master plan instead of sporadic resource consent processes?
Well, I think at the subdivision and development stage, definitely the preparation of a CIA would inform the subdivision and the layout of the development. You know, that's my experience with the CIA, having a better understanding of the cultural values, you know, and using that information in a creative and in a positive way, and informing any form of development, and you know, in quite a fundamental way often.
Yeah, great. Because I'll ask the planner when it comes to Mr. Tuck as well. And the only comment that I sort of had around ridge lines and how you made reference to more the plateau or in the theatre area. Ridge lines from a cultural perspective, and we don't have a CIA for this particular site, but ridge lines from a cultural perspective, in particular from the water, the sea in particular, provide landmarks in, you know, whether there's trees, whether there's humps or whatever those things are. So from that, I suppose the ridgeline comment for me is about the visual impact, and like you say, the landscape impact, plus that cultural landscape impact from the water, are key markers, in particular for journeys along the coast. So, sorry, I don't really have a question, but that was sort of building on the CIA, the values, you know. So if you've got your overarching sort of master plan of sorts, then those values are pretty much there. And then however they get interpreted or progressed in the resource consent stage, you've got the overarching. Then when you come down to site by site, there's the opportunity to say, well, in principle, actually, these are our key principles for the values of the cultural values, and in the detail is where you have those conversations. Otherwise, you're getting sporadic. You might get the repeat. You can get a risk of CIA for here, CIA for here, multiple CIAs. And one thing I am mindful of is one CIA that's done for one area informs the other area. So that's why I'm sort of just asking that question, which I'll ask Mr. Tuck when it comes to him. Is there the opportunity for cultural values to be and to inform the master plan as well, rather than sporadic resource consent processes? So, sorry, elaborating, I didn't have a question for you. I just wanted to flag. No, thank you.
No, I mean, I acknowledge certainly the relationship and previous projects I've been involved in of ridge lines as pathways, and and you know, there are some ridges. I have a bit of an aversion to the word lines, but anyway, that's okay. There are ridges through the site, and there are ridges through the Gulf Living Zone. There are ridges outside the Gulf Living Zone, and you know, which ones of these are you know, have higher cultural values than others. We don't know that. But I guess my point about the ridges in particular is that you know, I think in principle, landscape architects avoid building on very high prominent knolls and very high prominent ridges, and I accept that, and I'm not suggesting that that's something that should come out of this, but I think there are times when some ridges, and there are ridges, and then there are spurs, and there are, you know, so it's all within a hierarchy, and so some ridges it can be appropriate to build on them in preference to some of the other areas, and I guess that's why I'm wanting to avoid us straitjacketing us. But I agree with you that a CIA could inform of which ones of these potential high points or potential ridges are more significant from a cultural perspective than others.
Kapai. Thank you. Thank you.
I don't think we have any further questions, so thank you very much for your evidence, your rebuttal and your answers.
Okay.
I assume you're going to be sticking around for the rest of the presentation. There might be an opportunity for you to make a comeback.
Happy to.
So we'll see how we go. Now, we are scheduled to have the morning tea break at 11:15, but I think we'll just have a quick little 5-minute comfort stop now. We can box on for half an hour after that. Give it 5 minutes and then we'll come back to Mr. Tuck.
Leave that there for you, Steve.
Okay, I'll just mute the room.
We're just waiting for one commissioner to
Make a cup of tea.
This is very important.
kind of rough. Okay.
Thank you very much.
Thank you.
What's the date?
Yes.
Sure, continue. Sorry, that was a bit longer than 5 minutes, but that's fine.
Just before we start with this, one of the commissioners mentioned that these guys might be around to have a comment after the council's finished. They're heading back to get a flight, so they would need to be out of here by 3.
Oh,
But I
right.
intend to stick around till the end.
Right, I think. Okay, well, we'll see how we go.
Oh, they're food.
You can always watch the YouTube video to hear what we said if you can't be here in person. So, anyway, good morning, Mr. Tuck.
Good morning, everyone. I'm Steve Tuck. I'm a planner. I've been working in planning for about 15 years in New Zealand and Australia. I'm here today to provide planning evidence on behalf of Whale Bay Farm Limited. So I'll produce a summary of my evidence, which I intend to read through, and I'm happy to answer any questions from the commissioners after I read through it. And I'll try and pick up on those matters that you've signposted so far.
Okay, so we have this statement, so we're happy for you to read it or take us through it.
So my summary of evidence is as follows. The Kauri Cliff Zone, or KCZ, is unique to part of Whale Bay Farm Limited's property. It doesn't cover the whole property. The KCZ comprises the lodge, golf living, golf playing, and natural heritage subzones. My evidence in chief describes how master planning work has informed the proposed reconfiguration of the KCZ by shifting the golf living subzone north, reducing its extent, applying the golf playing subzone to areas where the golf living subzone is removed, and extending the lodge subzone mainly to the north. I support the Section 42A report recommendations with minor refinements recommended in my rebuttal evidence. Before discussing those plan provisions and minor refinements, to assist the panel, I provide some contextual observations about comments in Ms Millivan's rebuttal evidence on accidental discoveries, cultural impact assessment and walking trails. In the rebuttal evidence of Ms Millivan, she notes that future development may encounter unrecorded archaeological sites, especially near the cliffs. The proposed KCZ reconfiguration does not enable or position development sites near the cliffs, and you'll see this tomorrow, no doubt. I consider that the conditions of any future resource consents for residential subdivision in the KCZ would specify an accidental discovery protocol. This is typical, and indeed it's reinforced by some of the earthworks provisions in the proposed plan. This approach could be supplemented by a consent condition for earthworks monitoring, as has been the case for several resource consents granted at Kauri Cliffs today. Ms Millivan considers that the CIA should be prepared, and as has already been canvassed, I think Whale Bay Farm Limited and its expert team are in agreement with that. I agree that the CIA is important to identify and address potential effects on multicultural values. I do not consider that the CIA is a mandatory precursor to deciding the zone reconfiguration, and iwi and hapu parties who engaged directly with WBF in this process so far did not advise that CIA must be prepared now. And no doubt we'll discuss this further, but I consider that the CIA would add most value when it's developed in conjunction with and to inform future subdivision design work and subsequent resource consent applications. To that end, my recommended drafting of KCZ S1 requires effect on archaeological resources in the Kauri Cliff Zone to be considered in land use consenting processes. The subdivision consent applications, my drafting of sub R3 clause F reserves the consent authority's discretion over policy CEP10 matters. CEP10 requires consideration of effects on values significant to tangata whenua, pursuant to what is quite a comprehensive policy, TWP6. So a CIA would need to be produced to address those provisions as part of any subdivisional land use consenting process. Lastly, Ms Millivan's rebuttal evidence raises concerns about development of walkie trails, particularly to Whakatane Maunga. WBF's submission on the proposed plan briefly refers to some existing and future walking trails at the property, but it did not identify any proposal to develop trails around the Maunga. No trails around the Maunga are proposed in the master plan. The master plan area is actually quite some distance away from Whakatane Maunga and across Matodi Bay Road. The archaeological review of the master plan notes that a future residential subdivision might incorporate walking tracks with historic or archaeological interpretation. It does not discuss developing trails around the Maunga, as this is not part of WBF's current proposal. Any such development would have to be considered against the district plan provisions at the time. Just turning to the provisions. In the Kauri Cliff Zone Overview, Objectives and Policies, the Section 42A report recommends amendments to the overview, Objective 1 and Policies 4, 5 and 6, and I'm comfortable with those amendments. For the Gulf Living Subzone provisions, I've recommended amendments to standard KCZ S1 to ensure the considerations for activities in the reconfigured Gulf Living Subzone generally align with the new Coastal Environment chapter. Broadly, my recommendations take a conservative approach, I think, with less enabling permitted activity performance standards when compared to the notified plan. Otherwise, I recommend minor amendments to the Gulf Living Subzone provisions for clarity. For the Gulf Plain Subzone provisions, my rebuttal evidence, and this is paragraphs 20 to 25 of my rebuttal evidence, which shows the provision in question, Rule 8. I've noted just on review of the provisions that Rule 8 currently permits farming in the Gulf Living Subzone only. But the rule, if the zone reconfiguration is adopted, that rule should be amended to permit farming in the Gulf Plain Subzone too. And I'll explain why with reference to the maps in a second. But this is a minor amendment arising from the zone reconfiguration. It's important though, because where the Gulf Plain subzone currently permits farming activity or grazing activity, if it's lifted and replaced with the Gulf Living subzone, grazing should still be able to continue as a permitted activity. I understand that Mr. Wyeth has no concerns with this amendment. So what I'm speaking to here, just with reference to the plans for Fairview, the first 2 pages of the plans show what currently is and what's proposed. This is the current Gulf Living subzone in green, and there's a rule that permits farming activity there, and you'll probably see some cows wandering around there when you go out there tomorrow. If that's deleted and replaced with the Gulf Plain subzone, as on the second page, the Gulf Plain subzone should be updated to permit that farming so that it can continue in that same area.
Is this a sort of like a practical management change to allow sheep to graze the grass?
Yeah, it's literally just a mechanical issue to make sure that what's currently permitted can continue if the zone swaps around.
Right. So you use farm animals as part of your turf management strategy.
Oh, sorry.
Yeah.
It's just grazing. It's just the grazing of some stock.
The grazing of the areas around the golf course is part of the keep.
Yeah, it's principally in this
rather
valley.
than mow it, you allow animals to graze it.
It's quite a steep gully. You wouldn't want to take a ride on down there.
Okay. No, I just wanted to understand. So it's a management technique that you're wanting to allow that grazing. Yeah, it's farming. Yeah. Okay.
So if that rule R8 wasn't amended as I suggest, and the zones are changed, the grazing would obviously be permitted.
Yeah. Okay.
So just to close that off on the Gulf Plain subzone, paragraph 16. My summary, my other recommended amendments to the Gulf Plain subzone provisions are minor and ensure consistency with the rest of the KCC provisions. Now for the lodge subzone provisions, I recommend amending the provisions to account for the expansion of the lodge subzone. These amendments include updating permitted activity rules to account for the existing residential and visitor accommodation activities and amending the permitted GFA and height limits to align with the coastal environment standards. Discussed in paragraphs 17 to 19 of my rebuttal evidence, there is a minor disagreement between myself and Mr. Wyeth in relation to matter of control D to rule KCZ R2:1. In my evidence in chief, I recommended deleting clause D to that rule and replacing it with some revised wording. In the section 42A report, Mr. Wyeth has retained clause D and my recommended text is added as a new subclause E. In my view, if my recommended clause D text is adopted, the notified text of clause D is superfluous and can be deleted. So essentially, my view is that if my wording is adopted, there's no need to keep the old provision. And this was for rule KCZ R2, paragraphs 17 to 19 of my rebuttal. In relation to the Kauri Cliff Zone performance standards and matters of discretion, I recommend amendments to KCZ S1 to align building height, GFA, and external colour and material performance standards with the new coastal environment performance standards. This is quite conservative compared to the notified provisions, which are more enabling, but it appropriately recognises the introduction of the coastal environment layer to the eastern part of the Kauri Cliff Zone. The Section 42A report recommends amending KCZ S1 matter of discretion A and adding a new matter of discretion H. Mr. Goodwin's rebuttal evidence recommends a minor refinement to matter of discretion A, which in my view, if that is adopted, the matter of discretion H recommended by the Section 42A report is not needed. The subdivision provisions. So the Section 42A report recommends amending Rule Sub R3 R-21F and matter of discretion Sub R3 clause I. I discussed this in paragraphs 34 to 44 of my rebuttal evidence. And Mr. Goodwin's rebuttal evidence recommends refinements to those subdivision provisions, which I support because I consider that their precision will assist interpretation of the proposed plan. So in particular, there was some discussion about subdivision provisions in terms of whether the subdivision rules should, for the landscape planting and management plan, include a long list of all of the various assessment matters or whether a more concise approach is required. Mr. Weiss' Section 42A report produces a more refined and concise approach, and Mr. Goodwin has recommended some changes to that, which I think tidy it up, neaten it up, make it more concise and more efficient and effective. Paragraph 23 of my summary, there's a mapping error. I identified this in my evidence in chief and one of the maps in Appendix 2 to my evidence in chief. It seems that the rural production zone has been newly applied to an area that's in the Gulf Plain subzone. The Gulf Plain subzone is retained as well. Section 32 and Section 42A reports don't address this. I understand that Mr. Wyeth agrees with my recommendation to delete the rural production zone overlap and retain the Gulf Plain subzone. This is in the big set of plans before you, Commissioners. This is the very last map. Put a dotted red circle around the area in question. The rural zone's in green. The Gulf Plain subzone is
the red dotted circle.
Yeah. So the Gulf Plain subzone currently applies there, but the green for the rural production zone is being placed underneath it. Well, it should be the Kauri Cliff Zone. Yeah. It's unclear, not mentioned in the council reporting as to why that's been done, but the status quo is that hatched orange area is part of the Kauri Cliff Zone. It shouldn't have the green underneath it. You can see for the rest of the plan that there's grey underline, not green.
But is that recognised in your hearing report?
It wasn't.
Okay, so you can address that in your response.
Yeah, my understanding is just that I think you're
Yeah, correct. Yeah. I just wanted to make sure that there's a clear trail for us to follow. If we're agreed between all parties that it is in fact in your. Thanks.
Okay, so just to conclude, Commissioners, there's no major differences between my recommended provisions and those of the Section 42A report. The Section 42A report differs from my recommendations on minor elements of 4 rules, and the rebuttal evidence prepared by Mr. Goodwin and I provide solutions to those minor matters.
Okay, no, thank you very much, and thank you for working cooperatively with the council officers and getting such a large degree of agreement on the provisions. It certainly makes our job a lot easier, and it looks like the opt-in process is working quite well. So well done on all parties for embracing that. I've got a couple of questions for you. I just need to bring up a piece of. So I just wanted to go back to this whole master planning thing. Yes. Obviously, your planning evidence relies a lot on the assessment undertaken by Mr. Goodwin, it seems to me that the master plan provides this touchstone. That's the new buzzword we're introducing at the moment. And so you rely on Mr. Goodwin's evidence in that regard, but you've stopped short of recommending reference to the master plan and the special purpose provisions. And I just want to explore the rationale for that and whether there is room. Now, I'm just wondering whether, given its importance, do you agree that the master plan is a Section 32 document?
Yeah, it certainly contains elements that go to a Section 32 sort of assessment, and some of the pages that talk about the rationale behind the zone reconfiguration and why it's more effective to do it as proposed.
Now, I understand the unwillingness to want to have the master plan appear as a default rule.
Yes.
However, it seems to me that it's worth exploring whether reference to it as a guidance touchstone document is still something that could be explored and worth having. Particularly sending a signal to a consents planner that there is this document that has this wealth of information, principles, values that are there to help guide the merits of any proposal or development. So in that sense, do you think that there is room for it to be referred to in some way in the provisions?
Yeah, I would be very cautious about that, because the obvious concern, I think, as you understand, is that if it's referenced in the plan, this thing is a living document, as we mentioned, it's evolving over time, and it would be really unfortunate if in the future council planners were to point to the master plan as fixing a particular design or layout that then needs a plan change to realise.
Okay. I mean, for example, in the overview statement, you could potentially refer to a master plan. Rule.
No, it's not a rule.
And you could refer to the master plan in a generic sense to allow it to be a living document.
I think the master plan's value is really inherent for this rezoning exercise and demonstrating the feasibility of the rezoning and what could be achieved. I think it provides a good analysis of reasonably well-defined options. I just really have had experience in the past where references to master plans in plans have locked in certain development outcomes that have then needed to be unpicked at great cost.
Sure. Okay. Well, we're exploring ways in which that doesn't happen.
Yeah.
So the question was, whether you could refer to it in the overview statement without it becoming a default rule.
You could refer to it in the overview as Kauri Cliffs. Off the top of my head, I'm not going to suggest drafting right now. I suppose you could refer to it as the fact that there has been a master planning exercise undertaken.
Yeah. Okay, I suppose I'll put the question in a slightly different way. Would you expect a consents planner to have regard to the master plan in assessing subdivision or development proposal?
Not as I've drafted the provisions, no. And the reason for that being is that the master plan will inform various detailed technical assessments and the subdivision design, which is that's the documentation, the fine-grained detail that goes before the consents planner to make the decision. Yeah. So the master plan is like you said, a touchstone, but it's a touchstone that then is going to be taken forward through further iteration into a much more detailed set of reporting.
But in terms of setting context, basic principles, values, and approaches to how certain provisions have enabled development of subdivision, would it be potentially helpful to a consents planner? Well, for an applicant to refer to it and a consents planner to have regard to it. To say, well, look, these are the outcomes that were envisaged in the master plan, and hence that's why we're doing this in our subdivision and development.
I think the master plan demonstrates a way that the outcomes anticipated by the objectives and policies of the zone can be achieved. So I think a consents planner would need to be referring more to those provisions rather than the master plan to determine whether the design that's for them in the application achieves the objectives and policies rather than that high-level master plan.
Yeah, okay, but wouldn't the master, I'm playing devil's advocate here, so wouldn't the master plan potentially help the consents planner understand and put into context those objectives and policies?
Well, I think that's the AEE that you'd lodge with the resource consent application would talk to that material as need be. It doesn't need to be, again, as Mr. Goodwin mentioned, I'm conscious of time as well, that things may move on, and the master plan will inform the drafting of a consent application and the documents, and it can be, the principles therein can be enunciated within the AEE.
Okay. Okay. This might raise your blood pressure a little bit. Do you think there is scope to have the master plan referred to potentially in matters of discretion and assessment criteria?
No.
I'm expecting that answer. And that's what I'm thinking about, just to let everybody know, is whether there is merit to that. Obviously, you've carefully explained what you think the pitfalls are. I'm potentially looking at the advantages, potential ways in which those pitfalls could be avoided. It's not saying that I'm wedded to that outcome. I think the provisions are extremely well prepared as they stand. It's just about exploring the relationship of this, what I think is a very important document, and it being used, as I say, in that touchstone context to assist decision making in the future. So,
well, I suppose my thoughts on that, sir, are that the master plan, as we've said, is a living document. It'll be held by Waiau Bay Farm Limited. Now, I think within the evidence before you, I think all of the experts have set out that they have quite long-standing relationships with Waiau Bay Farm. So this is an expert team that has a relationship with the property and the landowner, and I think that team would retain the principles of the master plan going forwards in any application documents that were made.
Okay. Look, I won't take that any further. Thank you very much for your responses. In 95 of your primary evidence,
yes,
you refer about controlled activity status for exceedances of permitted height limits. I'm just sort of wondering, I'll let you get that paragraph up and let you familiarise yourself with it again.
'95?
Yeah. Look, my question's a reasonably sort of basic one, which is, does a controlled activity allow a consent authority enough discretion for a height infringement? I mean, as a controlled activity, your discretion is pretty limited. You couldn't, I mean, could you, if it's a controlled activity, could you actually control the actual height, change the height, or you would actually be stuck with the height that you've asked for? And I'm just wondering what level of control council could actually exercise as a controlled activity for a height exceedance?
I think, sir, that that question is actually probably a bit moot. In the Section 42A report, Mr. Wyeth recommended that controlled activity status not be accepted and a restricted discretionary activity be applied, and I've agreed with that.
Oh, you've agreed with it, right. I mean, we'll let that go. Sorry if I wasn't following that logic all the way through. Obviously, Mr. Wyeth has similar concern to me, so thank you for sorting that out. And you talked about the transportation rule. You've introduced that whole thing about the transportation rule.
Yep. Let's go into the weeds.
Is it?
A little bit, yes.
Okay, well, can you explain to me where we're at with that?
So it's agreed between Mr. Wyeth and myself. So the situation there was essentially that the operative plan, which was carried forward into the notified plan, very carefully sets up a restricted discretionary subdivision consenting pathway for the living subzone. However, as we know, the living subzone subdivision rule relates to 60 lots. There's a generic transportation rule in the transportation chapter that states that a subdivision that creates a driveway accessed by more than 8 houses is discretionary.
Yes.
So you set up this carefully constructed zone, and then the restricted discretionary consenting pathway is wiped out immediately by that transport rule. So my response to that was to craft up amendments to Rule 7 to carve out the living subzone, apply a restricted discretionary consenting pathway to it to maintain the overall consenting pathway for the zone, but to plug in and backfill the assessment matters by way of reference to all of the relevant standards of the transport chapter. So in terms of the assessment that would be undertaken, we'd be considering the same things. It's just that it's restricted discretionary rather than discretionary.
Okay, no, yeah, thank you. I think I'm following that, but I might.
And
You could explain that
just
later.
to add on to that, I sought advice from Mr. Collins, our transport expert, in terms of the relevant standards that should be applied. We had a more bespoke rule in this chapter, and some are included in the rule now. He's happy that covers relevant matters.
So really, I should just recall that matter's not in contention anymore. Yeah. Okay, and that's the most important. That's okay. That's it from me for now. Thank you very much. I'll see if the other commissioners have any questions.
Hi, Mr. Tutt, thank you. I've got a couple of questions. Sorry. So, in your evidence, your main evidence, page 150 here, paragraph 60, it's the main evidence, it makes reference to the RPS, objective 3.12, requires kaitiaki to be provided for decision making and stuff.
The appendix 6 to my evidence in chief.
Yes. Yeah, you had quite a bit of a lot of stuff, so.
Which paragraph, sorry?
69. I've got here on my PDF, it's page 150. And it's got issues significant to do.
Cool. Yes.
So my question I've got is, how will the rezoning proposal ensure tangata whenua values and kaitiaki responsibility are meaningfully addressed through a CIA and consent processes? So, yeah, I just wanted to sort of ask that question.
So I think, first of all, I might just background it by stating that I think that the CIA at the consenting phase is going to provide a much more fulsome assessment than it would if it was done now, because at the consenting phase there'll be much more detail for the CIA to grapple with. In terms of providing for meaningful exercise of kaitiakitanga, I think that that's probably an area that the CIA would provide some guidance on in terms of identifying the areas and values that are in play and mooting responses within the subdivision design, within the environmental management regime, perhaps the planting regime, accidental discovery protocols, all of those things. So I think the CIA is probably the baseline report that expresses the aspirations of tangata whenua for the exercise of kaitiaki within that part of Kauri Cliffs, and what Kauri Cliffs can do to facilitate that.
Cool. Yep, another quick question. Sorry. Yeah. Oh, so you've got the objectives and policies
Of the zone.
Of the zone, yeah, of the Kauri Cliff zone. My question is, well, from my observations, the objectives do not signal the need for a CIA, from what I've observed, and sort of the only obvious signal to consider as cultural values is in the coverage standard. So, yes, well, it's been said a CIA would be part of the resource consent process, but I don't sort of see any signals of where that CIA would come in. So that's my question. That's my sort of observation. So what additional, if any, objective or policy wording could secure CIA requirements for cultural monitoring, protection, because in your objective, you've got conservation environmental values. Fantastic. That's objective 2. Objective 1 is, enable us to do what we need to do.
So I think the simple answer is probably insertion of reference to the word cultural in objective
2.
Yeah, I was going to say objective 2.
Yeah. Okay.
But just to sort of broaden on what you said about the provisions pointing to consideration of cultural effects by way of the CIA. So I would refer to a couple of places, firstly in the zone, but also we're talking really about a subdivision in the living subzone today, aren't we? Predominantly. So the subdivision provisions are important as well. So just within, you pointed out that there is reference in the coverage standard, but there's also reference in standard 1. That's
new buildings.
So standard.
No, sorry, that's rule 1. Sorry.
Yeah, standard 1.
Yeah. I'm going to get to it. Yep.
So in the matter of discretion D in particular, and C. Sorry, I should say C and D. Both reference measures to the extent to which a proposal for C avoids remedies or mitigates.
Which rule number are we in?
Sorry, we're at standard 1.
Sorry, I was looking at the wrong bit.
We're looking at the matters of discretion.
Yeah.
Yes.
So C and D are the 2 that I would point to within the zone. And within the subdivision provisions, I probably went through this quite quickly in my summary, but rule sub R3 for subdivision of land to create a new allotment. The matters of discretion include clause F, consideration of the matters in CEP 10. So that's the broad policy in the coastal environment chapter. It sets out a very long list of matters that needs to be considered. One of the matters that needs to be considered is policy TWP 6, which is a comprehensive. Yeah. And I think that policy probably strongly points to the need for. Yeah. So you've sort of got to follow the
trail.
Yeah.
So following on that point, your coastal environment, part of your Gulf living rezoning is in the coastal environment, part's not. So
yes, but the subdivision rule applies to the whole Gulf living subzone. It doesn't distinguish between coastal environment and not.
Okay. Cool. I'm sorry, and just building on that standard 1, buildings or structures, and the matters of discretion, you made reference to C and to D. That talks about archaeology values, not cultural values. So there is definitely a difference.
Yes, there is a difference. Well, yes, that's one answer. I'll just bear with me, Commissioner. I just want to check something.
Okay.
So that's one.
I think the short answer is, as Commissioner Scott said, is perhaps add reference to the word cultural within those, within C and D.
Yeah. Because that would follow through from the hierarchy of the objective.
I'll just make a comment if I may. In the zone chapters, they've typically got this consider policy at the end, and that makes reference to the policy TWP6, which was just mentioned. And as a way of sort of consistency, we could certainly be a hook for that policy much more visible in the provisions. That would be consistent with Carrington Estate, for example. Something we consider further.
In addition,
I think that consistency around really just providing that clear hook to that policy in the time to penalty chapter.
yes, yeah, okay, no, I see what you mean.
Sensible idea.
Yeah.
Where would that go in the assessment manuals?
We did it for consistency with the other zone chapters. They've got this kind of consider policy, the last one.
Okay.
So whether I need to look at it, whether it's a standalone, And it talks about considering the following matters when assessing resource content applications,
Yeah,
maybe
there's a
signposts, the Tangata Whenua. Policy would then talks about any relevant to CIA.
And that's on the basis of the policies form effect on assessment criteria as well, right?
Yeah.
Thank you. Sorry. Thank you. Thank you. That's me for now. Thank you.
Thank you. I have, my first question relates to the master plan and the reference there to archaeology, noting that we don't have a CIA, so the current master plan doesn't have a section relating to that. However, what is outlined, and if it was part of the assessment criteria of the plan, it currently outlines on page, doesn't have a page number, sorry, design, process and considerations, and has a table of New Zealand archaeological sites.
Mm-hmm.
So currently, the archaeological report is the key document that identifies significant archaeological remains around the property, but also specifically outlines, as quoted, Māori archaeological sites concentrated around the bays for settlement. I know because the archaeologist is here, I'll refer this through you. In terms of the Māori sites and the defended car sites and ridges and headlands, I'm guessing that archaeologists must have got some sort of direction around what is or how it is a Māori site, and essentially in terms of the archaeological evidence, how and why that's concentrated in certain areas.
So the past sites along the coast, I believe a number of them are recorded archaeological sites on the NZAA. So I imagine that would be where the information came from, that they are recorded historic Māori sites. You might need to repeat the question though, because I'm not quite sure what you're asking.
Well, the archaeologist has referred to Māori sites and significant Māori archaeological sites. So in terms of the current evidence that the archaeologist has provided, but potentially some of the historic previous documents that went into the previous consents, what type of evidence or what type of information has been provided from to the archaeologists to identify it as being Māori sites and areas of significant archaeological remains relating to Māori archaeological sites?
Sure. So the archaeologist has done a site inspection and a desktop inspection and reviewed, obviously, the various heritage registers and archaeological registers. I think there's also, probably it comes a little bit from the relationship between Ngāti Kura and Kauri Cliffs, that there is just, I guess, general background knowledge that in particular along the coastline there are numerous sites of significance, whether they're recorded or unrecorded. And some of them, I mean, particularly in the south towards Tākau, you can see walking along alongside the cliffs that you can see the remnants of past sites that appeared, like, to the naked eye. It's just a grass paddock now, but you can sort of see these sites. So Kevin Texan being an expert archaeologist, I think would probably have made the appraisal that might be one of those unrecorded sites as background is sort of known about, I suppose, but not necessarily recorded.
Historically, there is old archaeology reports from the time when the golf course and road were developed.
Yeah.
So that's all registered, a lot of that's registered and there's registered sites as a result of that. And I think in a lot of what I've read, some of that's what's being held and brought forward in terms of what's on the archaeology
assessment.
The register where the recorded sites are. Heritage, New Zealand Register.
Yep.
Where the art sites recorded.
Well, so an example, I suppose, is that there are some sacred caves along the coastline that were brought to WBF's attention as warranting protection, and WBF worked to get those recorded on the NZ, the Heritage Register. And through this district plan process, obviously, has sought protection through the district plan as a significant site as well.
Just a supplementary question to that, for both the iwi and the hapu, are there iwi and hapu environmental plans that the council has on stock that the processing planner would take into account when processing that?
Yes, definitely.
I didn't see any reference to those documents as part of your evidence as the planner.
Yeah, the key iwi management plan would be the whangaroa iwi management plan. And obviously that would be relevant in the consenting process as a Section 104(1)(c) matter. That's another matter that needs to be taken into account. Yeah, you're right that it's omitted from my evidence. It's probably an oversight on my part, to be honest. Nonetheless, I have reviewed that iwi management plan, and I see nothing within the iwi management plan that, for example, would signal that this rezoning process needs to have a CIA provided up front. It is very clear and direct on the need for consultation with iwi, and that's something that's already been spoken about today. It sets out broad principles around the protection of different environmental spheres, and I think that the approach set out in the evidence of all of the experts demonstrates that how management could occur within those environmental spheres of fresh water, land, ngahere, the coast could be achieved.
I have another question around visitor accommodation. So the previous plan, the operative plan, didn't have a definition,
Right.
And so this new plan has this new definition, and to be consistent with the New Zealand planning standards. All of the orange and purple boxes, are they all visitor accommodation, or is the intent that the purple boxes, in alignment with the landscape evidence, are those more permanent residential units, or is it all visitor accommodation?
We're talking about these types of boxes?
Yes, the clustering of the
So those are indicative dwelling sites,
dwelling.
not visitor accommodation.
Okay.
And the different colours signify different footprints. So yellow being 300 square metres, purple being 400 square metres. That should be found in the legend on one of the plans. So visitor accommodation's not part of the Gulf Living subzone proposal. That's not saying that if a dwelling was built on one of those plots and was used for visitor accommodation, occasionally that couldn't happen. But visitor accommodation is really intended to be focused around the lodge subzone, and that I think is reflected in Rule 2 that I've prepared. Just going to quickly use that my bottom. Yep, so Rule 2 of my provisions appended to my rebuttal evidence deals with the question of visitor accommodation. And essentially what the rule is doing is recognising what is in the lodge subzone now, which is 15 units, and requiring a discretionary consent for more than that. There's a second controlled activity rule for additions and alterations, and then within the living subzone, there's no allowance for any existing visitor accommodation because there's nothing there at the moment. And if visitor accommodation units were constructed within the Gulf Living subzone, they would either need to meet the permitted activity rule there, or be considered as a discretionary activity. So they have to be in the building platform, or be considered as a discretionary activity. So it's a residential subdivision. I don't know, perhaps there could be scope for a future owner to lease the house through Airbnb or something like that, but I think that's highly unlikely because Cody Cliffs ultimately would be the manager of the land, and I would assume that through the sale and purchase agreements there would be restrictions on how the dwellings are used.
Just to follow on from the visitor accommodation matter, but this may be a question both tag team between yourself and Amy. So when Amy presented earlier this morning, there was commentary around wanting to grow the visitor accommodation and experience, I suppose you could say. Yeah, sorry, thank you, the experience. Could you elaborate on that, Miss Amy? Sorry, Amy?
Happy to. Kauri Cliffs is world-class destination, and our guests are discerning and have the world to choose where they'll visit, and they have, limited time.
Yes.
And it's they want to take the most from their experience that they can, whilst in the short time that they might be at Kauri Cliffs, which might be 3 or 4 nights. With that, there will be, whether it's enjoying a picnic, they just have the experience. What are the things that we're offering? What can we develop for them to enjoy on property? I think we mentioned walking trails earlier. That's actually since been consented. It wasn't at the Mulga. Walking trail, a golf course, clubhouse, fitness facilities,
cool,
leisure holiday type things. Really, that would be sort of. There's more and more.
Some of the activities.
Yeah, activities and experiences and.
Cool. Because, that's great, because it is about, I think I read in your evidence where it talked about Kauri Cliffs' legacy as a world-class destination. So sort of my question, I think, with wanting to increase accommodation, favourability maybe?
Some of it's around amenity for a future community, those residential development that may occur. So that might be casual dining facilities, golf access, fitness club, those types of things that would create that community.
Cool. Do you consider there could be a story there that it could enhance your clientele's experiences, knowledge, on potential, iwi participating in these walking trails, if a client was wanting to have a cultural experience alongside that? And I suppose it's about going forward, those opportunities of those conversations of cultural experience alongside your golfing experience, the coastal experience, all those sorts of things. So, I just wanted to know if you considered there was a story that could be told there.
Absolutely, and I think it's an important part of the experience that's offered. Cool. It's about how that's best evolved and with whom those conversations should be held. And I think there's something that, in honesty, and we're learning more about all the time, genuinely. For sure. But no, definitely, I think it's a key piece of, the experience in Northland, I think.
Great, because I think, so what I'm sort of looking at getting a bit of commentary on here is about the relationship. So the long-term relationship, opportunities, and what is the mechanism for, you've got multiple iwi and hapu that want to, that you've been engaging and having long-standing relationships with, So I suppose my question I have got here, what mechanism will support ongoing iwi and hapu participation? It's not necessarily in here.
I think I can give examples. The increased kōrero, conversations that have been had lately have evolved into great outcomes for everybody. And it's only through, sometimes tense conversations and also positive conversations or shared aspirations that these positive outcomes are coming about. And, very much since in the last few years, I think there's, just even recently, we harvested a radiata forest, which neighbours Whakarara. I think Moana has very clearly shared with me and multiple others the importance of that maunga. And we're a big company. I say that we're a small company and a big company. There's a lot of people doing a lot of different things, but the conversations and then me being able to piece bits together hopefully have positive, are having positive outcomes. And I sincerely feel that, and I hope that this is true. for everyone involved. But I agree. I think that there's, it's conversation and it's getting to understand and know more. And in fairness, I've got things wrong, where I might be consulting with the wrong party about the wrong thing. And, but I appreciate the feedback when I'm, redirected. And so it's sincere.
Yeah, there are multiple dynamics with union companies. So, and I think that's where from the CIA perspective, at a high level, rather than the transactional of the resource consents, I think is the component. I get it, the resource consent is the detailed design and opportunities to participate and inform, those sorts of things. But I think the overarching site, because you've got commercial forestry or forestry there that you're harvesting, so what's the intention going forward? So, those things will evolve in the master plan over time. Once we've harvested, next 10 years we're going to do X, Y, Z. And it's a matter of how can an overarching CIA as opposed to sporadic ones inform key principles, key values, I suppose. That's sort of.
And in that case of that recent harvest, we did consult, we were given some great advice and some shed aspiration. Native planting has now occurred.
Yeah.
So it is positive.
Yeah.
It's getting forward, I think. I think you're providing advice on some of the planting we've been doing. So
cool. No, it does sound. You've got those relationships and the ability to have those conversations, whether it's phone, texts, emails to Mr. Robinson, the Robinsons as well.
Yeah.
So
I think they're evolving and they're growing and
Cool. That was it. Thank you.
Thank you very much, Mr. Tuck, for your evidence and rebuttal and answers to our questions. Do you want to make a concluding statement, Ms. Buxley?
Thank you very much, Commissioner. The only thing that comes to mind, I think, is that the themes work together for a long time, and some of the questions and comments that came out of the commissioners have actually been really helpful to us, and I want to thank you. We have provided trusted and consistent advice. Any future steps of the property is likely to involve this team. And I think the comments and the feedback and the discussion that we've had today have been really helpful for us. So thank you very much for your time.
Thank you.
Well, thank you very much. Those comments are gratefully received. Thank you very much for your presentation. We are going to have now a proper morning tea break, which I think we're going to be for 20 minutes?
20 minutes.
Half an hour? Yep. Somewhere between 20 minutes and half an hour.
Yep.
Now, in accordance with Far North Hospitality, you're all welcome to join us for morning tea, and in particular the Kaitāia and the Kaitāia hospitality. Feel free to come next door and enjoy us for a cup of tea and scone. And then we'll recommence here. We'll make it 12:15.
Well, just apologies, we didn't bring any tuatua today.
Stopping the recording. And